Great to see you guys here. Great to see this big group. I'm Kelly Johnson. I'm president of the Confederation of Canadian Unions. Have been for the last 2 years and a bit. And I got to tell you, I'm ecstatic to see all the faces, all the returnees, people from the past, people of our future. This is great, just to see the amount of tables and people here. It's really a blessing for us. So I want to thank Scarlett. I think Scarlett went out of the room, but I want to thank Scarlett for setting up the tours of the Parliament buildings and Senate. I hope everyone had a good tour, enjoyed it. I don't think there'll be any more tours. Or are we going to go for a walkabout, Mike, after? No?
Well, you never know.
You never know. I don't know what Scarlett has. So we're going to start Labour School with Tim McSorley from the International Civil Liberties Monitoring Group. Recently, I think we've been sending out a lot of his material on listserv. Is that not right, Leanne? Yeah. So hopefully you've had a chance to read it, maybe develop some questions that you can ask Tim, and he's graciously came here and is going to make his presentation. So Tim, the floor is yours. Thank you very much.
Thanks a lot.
Thanks so much for having me here. It's really amazing to be here on behalf of the International Civil Liberties Monitoring Group. I'll talk about how we work a bit more, but we're a coalition of groups, and CCU has been a member since we started about a little under a decade ago, and it's really been, a little under 2 decades ago. And CCU support has really been invaluable to the work that we do. So I want to thank you for having me here today to be able to talk to you about some of the issues we work on and how we can address some of the threats to civil liberties that we continue to see here in Canada up until today. My name is Tim McSorley. I'm the National Coordinator with the International Civil Liberties Monitoring Group. It's a big name, but we're a small group. We're just 2 staff people who work at the ICLMG, and that's on purpose. We just lead a coalition of 46 groups. We produce information, and then we send it out to our members so that they're able to use it in defending their rights and in bringing concerns to your representatives to bring it back to your communities, and so that's really something that we rely on. We have 46 member organizations across the country, and it ranges from labor organizations and unions to environmental groups, faith-based groups, other human rights organizations, and we work together to make sure that since 2002, when Canada adopted its first anti-terrorism legislation, that we keep an eye on how anti-terrorism legislation and national security policies develop in Canada and its impact on civil liberties and human rights. And we came together because the writing was on the wall at the time, and groups had seen this before in Canada and other countries that, the Anti-Terrorism Act in Canada came after the tragedy of September 11th in the United States. But at the same time, we had seen already in Canada's history, when new national security laws are brought in so quickly in just a few months, it often leads to an overreach, a knee-jerk reaction, and an impact on civil liberties and human rights, often targeting the people who already are struggling to protect their rights the most in Canada and around the world already. So that's what brought us together in the first place in 2002, and since then we've been working to defend civil liberties and address human rights concerns around national security in Canada. And I've entitled it The War on, Confronting, whoops. Let's not move, oh, there we go. The War on Terror, and often we don't use the War on Terror very much anymore, but really we can see the timeline and how it's developed and how, even though that might not be the wording that we use, it kind of seems like it's old, that it's kind of out of date, it's still the issues that we're facing today, and we can trace a direct path from 2001 until today when the War on Terror was originally, started. Having some trouble with the mouse here. Oh, there we go. And just the last thing I want to mention before getting into the meat of things is just we do have, it sounds like you receive our materials already, but if you'd like to get more from what we're doing, every week on Thursdays we send out our News Digest, which is a rundown of civil liberties and national security issues in Canada around the world. And our website is at iclmg.ca. I wanted to start by talking a little bit about how we think about national security issues and why it's important to be considering civil liberties. And once I get through this, we'll kind of get into a few examples of where we see civil liberties being attacked by national security laws currently in Canada, and a couple stories and campaigns that we've worked on, and then into some of the legislative issues and what we can be doing to address it. I know it's just after lunch. I'll try to keep it a little bit lighter, and hopefully no one gets indigestion or anything like that from some of the things we got to talk about. But the first thing that we always try to address is how we think about national security. And the last time that Canada wrote down on paper what national security was actually in 2004 in the National Security Policy. And they said that it deals with threats that have the potential to undermine the security of the state or society, which is incredibly broad and which can, cover a lot of very legitimate issues. There are threats to society and to our state that we need to be addressing. There are people who commit acts of hatred, commit violence, and there needs to be a response. But often what we see is that there's a predominance put on the idea of the state versus the idea of society, and that's what we try to get at when we're talking about national security in Canada. So often what happens is that the protection of the state and those who are in power, governments and politicians, end up overreaching and then using national security laws to target groups who are challenging the status quo in Canada, not simply those who pose a violent threat, but those who are fighting for their rights and who are expressing an opinion that's different from the status quo. And we've seen that continuously throughout the history of Canada. This isn't new since 2001 or since the Anti-Terrorism Act. If we can go to the next slide. So Canada's first covert operations and surveillance operations were against Indigenous communities way back at the beginning of Canada, at the start of colonialism, and as Canada was being established. It moved on to cover a whole range of groups. It included Fenians who were advocating for an Irish republic. It covered pro-Indian democracy activists who were living in Canada and arguing against the colonization and British colonial rule of India. We saw it continue up through the 40s and 50s, the 60s, all the way to the 80s, covering groups as diverse from the LGBTQ community to labor activists to Quebec independence activists. And so really, even though we talk about this as something new sometimes, it's really been something that we've seen continually changing throughout time and a growth of the rules and powers that security agencies have, not just to confront what we would think of as violent threats, but to confront groups that are bringing up and challenging the status quo in Canada and exercising freedom of speech, freedom of expression, and their political views. And most recently, of course, in the past decade, the two of the groups that we've seen the most focus on are Arab and Muslim Canadians and people of Arab and Muslim descent in their communities, as well as a growing focus on Indigenous activists and environmental activists. So we'll talk about that. We can kind of go through. Go to the next one. So what does this look like? What we see more and more, or what we've seen throughout time, but what we continue to see, and it's been growing the past decade, is a targeting of specific communities and people, as kind of demonstrated. This targeting creates suspicion between neighbors. It actually causes more insecurity in communities because people lose trust in each other. We see that a lot in Csis visits to workplaces and homes and places of worship, where then people start not talking to each other, they become suspicious of each other, and actually leads to greater insecurity in communities and greater threats instead of actually increasing our security. We see it through invasive searches, interrogation, detention when traveling, and up to including imprisonment and torture, and we'll get into a case of that in the next slides. We also see, as I said, an increase of surveillance and its impact on privacy rights and how it leads to a chill on dissent. So people being scared to assemble, being scared to speak out, withholding their opinions because of this, because they know they're being watched, but also being worried about what kind of information is being collected about them and how it could be used. And finally, one of the things that we find, and it's been a big debate in the past 2 years, is how it can also cause a distraction from things that cause real violence and real danger in society. So one of the arguments that we've always put forward is that, yes, we need to be discussing terrorism and its threat, but often in the public debate, it tends to outweigh things like gender-based violence, other forms of violence in our societies, hate crimes. There was recently a shift where we've been talking about confronting hate crimes and white supremacist crimes. For the first time ever, white supremacist groups were added to a watch list in Canada. But at the same time, it's a double-edged sword. That watch list has 60 organizations, 2 of which are white nationalist, and the others are all, I think it's about 85% are Arab and Muslim Arab and Muslim groups. which are, a lot of them are legitimately have committed crimes, but we can see how these rules are still applied, even though it's changing, how it's applied in a very uneven way. Go to the next one. So the way we try to confront that, and something that hopefully we can talk about a bit more later, is by taking a human rights approach and civil liberties approach to national security, and to how we even think about security in general. So for us, we're often told that rights and security is a zero sum. We have to balance it out. We have to give up our rights in order to have security. But for us, the way we've seen it, and the way that the rights system has established, it's not, rights haven't just appeared now. It's been centuries that people have fought for rights and have developed a system of what we see and what's come out especially in the Canadian Charter of Rights and Freedoms. And that those are inherent rights, and that it isn't an issue of trading those away, but rather figuring out where there may need to be limits, but not saying that we need to give up these rights because our security is in fact embedded in those rights, that we are more secure because we have rights such as freedom of movement, freedom of expression, freedom of religion, the right to a fair trial, the right to vote, and things like that. And so we're always skeptical and concerned when we're said that we have to trade those away in order to increase our security. Because really what we've seen is that as we give those away, often people's security diminishes, often there's more division in society, often it's used to further take away the rights of people who are on the margins or who are already facing a limitation on their rights. And the final thing is that one of the concerns we have is that often we're told to do this, but to only trust the government and to trust national security agencies that this needs to be done. And what we've always fought for and continue to fight for is that if we are putting limits on any rights, that it's debated in public, that there's clear evidence, and that it's proportional. But what we've seen, especially in the last few years, in 2015 with the Anti-Terrorism Act that was brought in by the Conservative government at that time, they brought in a massive omnibus bill in a period of 3 months. And it was a problem. There was the attack on Parliament Hill, and that needed to be addressed. But at the same time, those kinds of, as I mentioned, those kinds of knee-jerk reactions often lead to an overreach, and then we're told to just trust us, and we're not given the justification for why we need this increase in surveillance powers, in arrest powers, in limiting the right to access the evidence being used against somebody who's accused of a crime. And then once it passes, we miss the opportunity that we can challenge it. But it's in those debates that we're supposed to be given the reasons this is happening, and that often doesn't happen. So that's something that we're continuing to confront today. Go then, next one. Before I go further, I just wanted to talk about some of the agencies and some of the differences between them, because I'll be mentioning them throughout. RCMP, I think everyone is familiar with them. One of the things to keep in mind is that they're a law enforcement agency. They're the prime federal law enforcement agency that's tasked with dealing with national security in Canada. But one of the important things to keep in mind is that they can arrest people. And then eventually what they do, in theory, it doesn't always happen that way, but goes to court, can be challenged in an open court, and if they have committed wrongdoing, violated somebody's rights, that can be challenged, and that will play a part in the proceedings. It doesn't always work out that way, but at least that's how law enforcement and going to a criminal trial works in Canada, or is supposed to work. But then we have the Canadian Security Intelligence Service and the Communication Security Establishment, which are two intelligence agencies. And the thing to keep in mind about intelligence agencies is that they're not law enforcement. They can't arrest you, they can't lay charges. Even what they collect isn't allowed often to be used in court because it's not considered evidence. It's intelligence, it's information, but it could be based on conversations, hearsay, rumors. It can be very vague, so it can't be included. But they have incredible powers of surveillance and providing information to the government that then sets the policies of the government, that then sets the policies of what the RCMP investigates and how those criminal proceedings go forward. And one of the things that we've been very concerned about, especially with Csis, is that they've been granted new disruption powers that gives them police-like powers, but without the accountability that we see with police agencies that eventually would have to go to court and would be able to be challenged. I'll talk about it more later on, but for example, Csis being given powers to impede people's movement, disrupt their communications and things like that through a secret warrant, but never having to actually go to open court to defend it. One last thing just about the CSE. Most people don't know about it. Many of you may. I'm not sure. It's Canada's version of the National Security Agency in the United States. Their job is to look internationally. They've operated largely in secret until the last decade. It was only actually in the last months that they have a formal act in Parliament that sets them up. They're not supposed to spy on Canadians, but we know that they do. And so I'll mention a few cases of that later on. But they primarily do what's called signals intelligence, which is collecting monitoring phone calls, internet, anything that has to do with telecommunications. Next one. So I wanted to start by talking about one of the individuals we've been working with over the past 20 years, and whose story I think exemplifies some of the issues that we're confronting when we talk about national security and the national security overreach. Has anyone in the room heard of the story of Abu Sufyan Abdulrazik? We have a couple people? Okay, so I won't be, that's good. It's good that a few people know about it. And also I'm glad because it means I'm not just repeating things that everyone's heard before. So Abu Sufyan Abdulrazik is a Sudanese Canadian. He was born in Sudan, left Sudan in 1990 because he was, as a refugee, because he was targeted for protesting against the government of Omar al-Bashir. And many of you may recognize that name. He was the dictator who stayed in power as president of Sudan up until just very recently, where protests basically deposed him. And he's known for his grave human rights violations. So Abu Sufyan left Sudan to come to Canada as a refugee in 1990 and gained his citizenship in 1995. He lived in Canada peacefully until the early 2000s. At that point, he started to be targeted by Csis for interrogation and questioning because he attended the same mosque as somebody who was arrested on legitimate terrorism grounds, Ahmed Razam, who was known as the Millennium Bomber and was arrested in the United States. But this was the type of guilt by association that we often see because they attended the same mosque and they knew each other, even though there were no accusations against Abu Sufyan about being involved in that plot. And in fact, he testified at Razam's trial for the prosecution. They continued to question him and sow suspicion around what his implications were, even though there was no evidence about any implication. So eventually, he decided that he would, not for that reason, but his mother fell ill, and so he decided it was a good time to go to Sudan. Things had changed. He didn't, even though it was the same president, there weren't as many crackdowns going on people, and so he thought it was an important time to go visit his mother, who was very ill in 2003. As soon as he got there, he was arrested by the Sudanese secret services. And as we found out later, that it was on the request of Csis, even though they denied it for several years until access to information requests and other investigations came out and showed that throughout that whole time, Csis had been in touch with the Sudanese officials and had requested his arrest. So he was arrested in 2003, kept in prison, and it hasn't been proven in court, but has given very credible allegations of torture. While he was there, he informed his lawyers, he informed consular services, but nothing happened. He was never charged, never tried, never went before a judge, and eventually was simply released. But what we know of that time is that he was told that he was visited by Csis. Csis provided questions to his Sudanese interrogators and visited by the FBI and told that if you do not cooperate, you will never leave Sudan. This will become your Guantanamo, referring to Guantanamo Bay Prison, you know, the infamous prison where there's still people who have been there for, you know, almost 2 decades now without charge. So he admits he told them what they wanted to hear in order to just get out of prison. Eventually, he's released the first time for several months, but then he's placed under house arrest. He tries to return to Canada, but they won't allow him to return to Canada because of the U.S. no-fly list, despite the fact he wouldn't be flying into the U.S. or over the United States, and that's a continuing problem that we see today, that Canadian airlines don't allow people to fly in it, even though, because of the U.S. no-fly list, even though the flight goes nowhere near the United States. So he can't return to Canada at that point. Eventually, in 2005, no, sorry, I'm skipping ahead a little bit. In 2005, the Sudanese government officially exonerates him. That's in July 2005. He's still unable to return home to Canada because Canada now won't issue him a new passport so he can return to Canada, and he's trying to return. And eventually he's rearrested, ironically, even after being exonerated, again in 2005, just before a high-level delegation from Canada comes on a trade mission to Sudan. And he's not allowed to meet with Canadian officials. And they fly back on a plane that has lots of empty seats. They could have brought him back home. They left him in Sudan. Where again during that period, he's given credible testimony that he was tortured and even has shown scars that he has because of what he went through. Eventually, though, again, the Sudanese government says, well, we can't hold you. There's nothing against you. We're going to release you. So he's released in July 26, after 10 months. Again, he tries to return to Canada. He's again refused a passport, and even the Canadian government refuses the Sudanese government's offer to fly him back at their expense to Canada. And then just a few months later, his struggles continue because the US places him on their terrorist watch list, which is different from their no-fly list. They have a lot of different lists in the United States. And that terrorist watch list was actually in the news recently because it was declared unconstitutional after a 10-year court case by a US court. Because of the information that's used to put people on that list is so vague and unfounded, and it's impossible to challenge it once you are on that list. So he's placed on that list. Because of that, he gets placed on the UN list, which still exists today. These are all issues that we're still facing today, a decade later. He's placed on a UN list, which means that he can't have access to any resources in Canada. Canadian law says if you're on this UN list, you can't have access to funds, so his bank accounts are frozen, no one can provide you support. So he's essentially destitute, without a passport, and stuck in Sudan. So what does he do? He goes to the Canadian Embassy for help. They actually allow him to stay there from starting in 2008 for an entire year. They force him to sleep in the bathroom. He sleeps in the gym. They still won't issue him a passport, even though they say they're letting him stay there because his rights are under threat. They won't let him return to Canada. And what's come out since then is that throughout that time, both Csis and the United States were both putting pressure on the Canadian government to say, don't let him return to Canada, all the time without presenting any charges or any real evidence of anything why he should come back to Canada. He shouldn't be allowed back to Canada. And again, it seems like that all stems back to these allegations of guilt by association because of other people who attended his mosque, people who he had met in Sudan and on other travels, but never because of anything that he himself had ever done. So finally, he launches a court case to get a passport and challenge under Section 8 of the Charter of Rights, which says that a Canadian citizen has a right to return to Canada. It goes to federal court. It's a drawn-out court case. People in Canada know this story. He's from Montreal. They knew him from before then, and people from his community rally, and they actually raise $1,000 against the law because he's on this UN terrorist list. So 115 people contribute to buy a $1,000 ticket, knowing that they could possibly face sanctions themselves because they're violating this law, to buy him a ticket because they know, and this story has been in the news, people know that his rights are being violated. They know him from before he left Canada, and it's absurd that this is continuing to happen. He's still not able to get a passport to use that ticket, but eventually in the summer of 2009, a federal court finds that the government, it was a scathing indictment of the government saying, you have denied this man his rights, there's no evidence, no proof. Csis and the RCMP had actually come out and said in 2006 that they had no evidence tying him to any criminal activities or anything that would link him clearly to terrorist organizations, and yet he was still stuck in Sudan. Finally, in July 2009, he's able to return home. So we would think that would be the end of the story. Of course, not for him, because obviously he's gone through this horrible, traumatic, he's going to be dealing with this for the rest of his life. He has 2 children living in Canada who hadn't seen him for all that time. He's living with this for the rest of his life. And you would think that after all that, clearing him up, coming back to Canada, that would be done. It takes another 2 years to get off the UN terrorist list. So all that time, he's not allowed to work, no one is allowed to give him money, he's living off the support, staying with friends, living off his support from friends because of the fact that he's still on this terrorism watch list. Eventually in 2011, he's able to get off the list. So his life has slowly returned to whatever normalcy he can have. Like many people who go through something like that, he filed a civil suit against the Canadian government for $27 million. Because of the breach of his rights and what he went through. It's a lot of money for everyone, but looking at what he went through and what he suffered through, and looking at previous court claims, it's an amount that's justifiable. And really what he wanted from the very beginning is simply a recognition and an apology and something to help him get back on his feet. He says he doesn't necessarily even need that amount of money, but he's asking for something that will make a difference so that the Canadian government will never do this again. It looked like it would finally go to trial in fall 2018, so again, 7 years later it takes for it to actually look like it will even go to trial. And then the Canadian government, the current government, says that, well, it's been so long, we need to review all the evidence again to make sure that you have all the evidence you need for your case. And his lawyers say, well, we have all the information we need. We're ready to proceed. But because it's a legal motion under the Evidence Act, and it's one that the judge needs to adhere to if either of the parties say that they want another review to make sure that the evidence, that there's no secret evidence that would come out in the court case. And so that's gone back to review, and so it'll still be a few more years before it can even proceed. So this is what we're facing, and I'd like to say, maybe we can go to the next slide. I'd like to say that this is, you know, a unique and a single incident, but what we've seen in his case, we've seen in other cases where the government and security agencies are involved every step of the way, even though they deny it. He, like others, was never charged and never brought before a judge. He didn't have access to the evidence used against him. There were rumors, leaks, and innuendos all throughout that time, leaks to journalists without a shred of evidence, and that afterwards Csis denied even leaking. He suffered illegal detention, interrogation, and torture, and denied his rights to return to Canada. So we'll go to the next slide. So as I said, this isn't sadly unique. What we see is a whole slew of Canadian laws that allow for these things to continue to happen, and that we've seen it happen to people apart from Abu Sufyan Abdul Razik throughout the years, and laws that still allow for maybe not somebody to go through everything that he went through, but different parts of what he went through. First, you wouldn't know if you're on the no-fly list unless you're stopped from flying. You're not informed once you're put on it. And then once you try to get off of it, you're not given access to the information that put you on in the first place, so you can't mount a full defense. Our terrorist watch lists in Canada and the United States persist and continue the same way. Canadian Border Services continue to use that same terrorist watch list from the United States to keep people out of Canada. The list that's been found unconstitutional. And there's other laws that follow the same suit. So security certificates, which are an immigration tool, are used to detain, arrest, and put people under house arrest and under bail conditions, despite them never being charged with a crime and despite them not having access to the evidence used against them. And finally, we can say that this is all based in security, but we can't deny the fact that there's a clear string of racism, Islamophobia that runs all the way through this. It's not, you know, just random that it's only been Muslim men who have been put on under security certificates who have been been stopped by Canada from returning to home and who have been tortured abroad because of that. So one of the things to point out is that Csis alleges, or throughout this whole thing, now they're saying they had nothing on him. But this all started before Abu Sufyan went to Sudan. And one of the things that we've seen recurring in his case and cases like Mohair Arar and Abdul al-Malki, other people have been tortured abroad, is that Csis may have information about somebody, but they allow that person to leave the country to another country such as Syria or Egypt or Sudan, where they don't have the same rights protections, and then share that information with those countries and tell them to do something about it, because they know they can't do anything in Canada. And so it's this really, I can't think of another word except despicable. It's a really despicable tactic of making sure that in Canada, that, oh, we're not violating rights here, but then once somebody leaves the country, of finding a way that their rights are violated somewhere else, all in the name of our security. And we haven't seen, in all those cases, you know, especially of Canadians who have been tortured abroad, a single one where they've actually been credibly linked to terrorism or face charges and imprisoned. I'll go to the next slide. So the next one I wanted to touch on, so that's one side of national security, and that's when they talk about confronting what we typically think of as terrorism. The other thing that we continue to see with national security and with Csis and the RCMP is a targeting of activists in Canada. And in fact, since 2011, we've really seen an upsurge in the rhetoric. That was when the Harper government started referring to anti-pipeline activists as foreign-funded radicals and likening them to eco-terrorists. And that could just be seen as rhetoric. But what we've also seen over time as people, again, through access to information requests, through court cases, there's been revelations, for example, of Project Sitka from the RCMP, where they held files and dossiers starting on thousands of Indigenous activists, and narrowed it down eventually to about 350 Indigenous activists who never committed a crime, were involved in Auto No More, involved in peaceful protests, and yet were labeled domestic extremism and placed on the National Tactical Intelligence Priority List, which is essentially the list of priorities for the anti-terrorism work that the RCMP does. They've said that they've shut down that program. What we've seen in the past is often a program is shut down, but the name has changed, so there's continuing concern about how the RCMP is acting in these situations. More recently, we saw the protest papers. Have people heard of the protest papers? It came out of BC this summer. So essentially, this dates back several years to a complaint filed by environmental organizations in BC that Csis was illegally surveilling them. They took it to the Csis's review agency. That review agency, I won't get into all the critiques of it, but it's been a flawed system. It's being improved right now. We're hoping it will get better. They found that Csis did not break the law. But the recourse in that case is to bring it, in that case, you can bring it to judicial review in front of a judge. So that's what they've done. That was in 2014 that they originally filed that CERC complaint, the review body complaint. They were told that they weren't allowed, that because it was a private hearing and that it's confidential, that they weren't even allowed to release their own submissions to the review process publicly. So they weren't allowed to talk about what they testified about in that review committee hearing, all the while waiting for their court case. It finally went to court this summer. There was a disclosure where the government had to reveal information in the court case. So that's finally now that we know what these protest papers are, and it's thousands of pages documenting Csis surveillance of environmental organizations and Indigenous groups, primarily protesting pipelines and tanker traffic in BC. Never accused of committing a crime, but being surveilled and followed by Canadian security services. And then finally, it's not just in Canada that we see Canada doing this. We've worked with Mining Watch and other groups to bring up the issue in other countries around how Canada is complicit with other countries labeling environmental activists and land defenders as being national security threats. So one primary example is in Mexico, where Canada supported, and the Canadian Embassy supported, a company named Blackfire that was running a mine there, despite knowing that their security forces were attacking protesters, injuring protesters, and eventually a protester named Mariano Abarca was murdered by their security forces. And throughout that whole time, he had gone to the embassy asking for support, and he was rejected any kind of support, and the Canadian government continued to work with the Mexican government to support Blackfire in their mining activities. That's just one example, but in other countries, I want to get this right, in Ecuador, Canada actually helped and lobbied to pass a mining law that served to further protect Canadian mining interests at the expense of local community activists. So we've documented not just how Canada does it here, but also how they're part of this international system that helps to target protesters internationally for economic interests. So those are just those, I wanted to give kind of two examples of how we see it playing out. And now I want to talk about two examples of legislation that are newish, one from 2015 but was recently reinforced, and one that's completely new under the Liberal government, just to kind of give an idea of what we're up against right now, and also how this isn't slowing down, and despite, I don't want to get into the elections or anything like that right now, but despite the rhetoric of fighting to protect our rights, how the security establishment and security services always seem to be an exception to that, despite what governments say. So the first is I wanted to talk about new surveillance powers. So we've been critical of what Csis and the CSE can collect, and that they can collect a whole range of information that isn't just about people who cause a threat to Canada. And it came out in 2016 that Csis have been violating the law for a decade, collecting information and retaining information about people who weren't a threat to Canada and had lied to the courts about it. So in 2016, it went to court. It was actually a judge. How did it get to court? It was a judge who was reviewing the documents of Csis who said, we need to review this. They took it through and they realized, and he said, you've been lying to us for the past decade. You have to suspend this program. So they did. They were supposed to destroy that information. And they kept delaying, and it was frustrating. We thought eventually it would happen, and we weren't quite sure what was going to happen with that information, but the idea was that it should be destroyed. But then what happened was that what we found out was actually in the works. is that in 2017, when the federal Liberal government introduced the new National Security Act, there was legislation in there to legitimize and legalize that exact same kind of collection that CSIS had been doing for 10 years illegally, and to allow it to now continue under a legal framework. And we were told, well, see, now it's legal. There's safeguards. It has to, in certain cases, it has to go through a judge for them to access that information. They have to get ministerial authorizations. But what we see is that CSIS overreaching its step, collecting information, doing surveillance that was outside its boundaries, and instead of being told, no, you can't do that, they're told, okay, let's find a way for you to be able to do that under the law. Which is incredibly concerning because we're never told and given the justification for why they need to do that. We're just told, well, they were doing it, there's good reasons they were doing it, we're going to make sure they can continue doing it. So now they can collect what they call data sets on Canadians and of foreign intelligence. There's rules around the Canadian collection and foreign intelligence collection, which are good. They're not strong enough, but they're better than they were before. So it has to be authorized by the minister. There's an external oversight body called the Intelligence Commissioner now that needs to approve it before it can go into place. But it's still all in secret. These aren't rendered public, and it's still highly concerning. But one of the most concerning things, we'll stay with the slide, is this idea of publicly available information that's been added for both CSIS and the CSC, and that they can collect this kind of information. And it's not governed by the same rules of the other data sets they can collect. And essentially, it's any information that's out there publicly that's either available publicly or can be bought or attained by subscription. So if we think about what that means, we were told by CSIS during committee hearings that, well, it just means that we can, collect the phone book and hold on to it. It's a little disingenuous for them to argue that they were never allowed to have a phone book in the past. What it does mean, and what we've heard from other experts, is that it means that they'll be allowed to collect information if they think it's likely to be relevant to their work. So it's a very vague standard. Information off of social media sites, information off of any databases that are possibly for sale. And what we know is that there's a growing market of gray market data brokers who scrape websites, who look for weaknesses in firewalls and in server protections, and then scrape up the information that they can, and then put it on the market. So this is essentially allowing both CSIS and the CSC to start buying and purchasing that kind of information. If information is leaked through a hack and made public on the internet, we ask constantly, and others ask constantly throughout hearings on the bill, whether or not that would be excluded. And we were never given a straight answer about whether or not that would be excluded. So our only conclusion is that it can be included. We don't know for sure they will do that, but they're not saying that they won't do that. And that's information that shouldn't be out there in the public. But it's publicly available at the time that CSIS is looking for that information. So this is highly concerning, and it's a new law that was brought in with the National Security Act of 2017 that just received royal assent over the summer. Go to the next slide. And then the last power I'd like to talk about is just CSIS's disruption powers. And this is something I mentioned at the beginning about how they're getting police-like powers. So before, CSIS was only allowed to collect intelligence. They were only able to take in information and then give it to the government. Since 2015, under the Anti-Terrorism Act brought in by the Harper government, they've been allowed to engage in threat reduction or disruption powers. And you can see, I won't go through the whole list, but you can see there some of the things they're allowed to do, including disrupting communication, fabricating documents, interfering with movement, impersonating a person apart from a police officer. Those are things that they can do with a warrant. So a judge has to approve that, but it's a secret warrant that we will never see. There have to be reports saying when they've asked for these powers and how many times they asked for it. But once they get that warrant and can carry it out, there's no guarantee that anyone will ever look at how it was carried out and what happened with it. We know from the previous example that they've lied to their oversight bodies before and review bodies before. So we're very concerned that we're seeing this move towards CSIS being given police-like powers, even though they operate in secret. So you could have your communication interfered with, you would never know that it's happening or who is doing it, and you would never have a chance to challenge it yourself afterwards. So even if CSIS has to go back before a judge afterwards and say what they did and how they carried out the warrant, you won't be there to challenge it and talk about how it impacted you. It's all based on what CSIS tells them. So it brings us to this idea of digital barn burning. I think the next slide kind of gives an idea. Yeah, so this is a cartoon from 1980, following the McDonald Commission. So Csis was actually formed after the McDonald Commission, where it was revealed, there had already been revelations, but this commission kind of put it all out there, about the RCMP's dirty tricks campaigns. And at that time, there was the RCMP Security Service and RCMP Law Enforcement. And basically what was realized was that if you combine security services and law enforcement and give security services that work in secret all these powers, you're going to have overreach, you're going to have people's rights being trampled on. And so what we saw was that they would illegally bug communications, that they would break in and steal documents. They did it to, especially in Quebec, breaking into media offices and stealing documents, impersonating people, really engaging in the worst of what you can think of for a security agency. And the culmination of this was the barn burning incident that maybe some of you have heard about. The FLQ, the radical group, and that had committed violence, and that there were concerns about. But they were going to meet with the Black Panthers in a barn in Quebec to discuss how they could work together. So it raises questions, of course, but what the RCMP did to prevent it is they burnt down the barn where they were supposed to be meeting. Without knowing that the meeting was for sure going to take place, without any real thought about the danger that would put the people who live on the farm into, whether or not, so it raised all kinds of questions, and this came out. And the RCMP officer who revealed it and was testifying about it said, well, it's not so bad. In the 20 years I've been on the force, it's the only time we've done it. So feeling like, well, we don't do this all the time, it's okay that we did it once. And so this is why we bring up this question of what's called this idea of digital barn burning. So if you're allowed to so the idea of this was to keep people from being able to talk to each other. So if you're able to prevent people from moving, if you're able to prevent people from communicating online, taking down websites, taking down forums, interfering with emails, essentially what you're doing is doing the same thing. You're in secret making sure that people can't speak to each other, which was a goal of this digital barn burning. It might not put people in the same kind of physical danger as burning down a barn. It might not be as kind of, controversial or illustrious or whatever you want to call it, but it has the same impact. And that's what we're seeing as a return to that. And that's one of our biggest concerns, is that why, if we know these lessons of the past, do we feel that we can go back to it now? There are new safeguards. At the time, the RCMP wasn't getting warrants. So there is a judge overseeing it, but as I said, it's done in secret. We don't know what's going to happen afterwards, and there's no real accountability. They have to be reviewed by review agencies. I think that might be on the next slide. It might not be. Yeah, so I mentioned here some of the achievements we've had, but one of them is getting the first National Security and Intelligence Review Agency that can review all of national security activities in Canada, which is great. So they'll be reviewing how Csis carries out these warrants. But they operate in secret. The reports are confidential until it's vetted by Csis and the government and then released to the public, so there's often a lot that we don't know, or is that released in very vague terms. So we see it actually, though, still as a victory that we have this National Security and Intelligence Review Agency, because up until now, it's been fragmented. There's a review agency for the RCMP, for CSE, for Csis. They're not allowed to talk to each other. They're not allowed to look at any other organizations like Border Services or Global Affairs whose consular services are supposed to make sure that people aren't being tortured abroad. So this, for us, is a win. It came out of the Arar inquiry after Maher Arar was tortured in Syria. And it took a decade for it to come into place. It was established with Bill C-59, which is a real victory for our coalition and for groups that we work with. Some of the other things that we've done and being able to achieve through collective action is keep the surveillance powers from getting even worse. So I know it looks bad, but what's being asked for was even worse under this idea of lawful access that would grant police agencies the ability without a warrant to request internet records from internet companies. And we're able to, with groups, fight back against that in 2013 and make sure it didn't pass. We made C-51 an election issue in 2015 and made sure that the Liberals responded. It wasn't the response that we completely wanted, but there were some good things in Bill C-59. But as I showed, and there's other things we can't even get into today because it's a 150-page bill, they brought in a lot of other powers that are highly concerning as well, so we're not there yet. And yeah, as I mentioned, important amendments to C-59. So go to the next one. I won't go through all these, but what we're doing right now for the elections is we put out a campaign of the top 10 asks that we have for the parties. It includes a lot of what I've talked about today, but we're asking the parties to commit to these. So far, the only one that has committed, although in vague terms to it, is the NDP. But we're hopeful that others will come on board as well. And this kind of lays out what we're hoping in a large way. We're going to narrow down because that's a lot to cover. In a large way, what we want to bring into the next session of Parliament. Go to the next one. And we've launched a campaign. And some of you may have seen it, or maybe it was sent out, but so that people can write to the candidates in their ridings, asking them to endorse, explaining each of the asks and asking them to endorse those 10 asks and to bring it into the next Parliament and get it initiated as part of their party's platform. So you can go to ICLMG.ca elections 2019 to do that. And then I think, is there another one? And that's it. I'd love to have questions. I have a bit of time now. I think we have a bit more time. Yeah? Yeah, I'd love to have some questions. And if you'd like to follow our work, that's all our social media handles and everything on the screen there. And yeah, thanks so much.
Like you were saying earlier on, if there's virtually no civilian oversight for Csis and CSE there, is there any progress being made on that front?
Yeah, so there is some progress. So I may have misspoken. There is civilian oversight, but they operate in secret. So there's CSIRC, the Security and Intelligence Review Committee, which up until recently was a review body for Csis. Exactly. Yeah. Well, it's even worse than that. So it's not. So for that, it's not even parliamentarians or a judge. It's people appointed by the government. One of the chairs. Do people know who Arthur Porter was? No. Arthur Porter was a doctor living in Montreal. Yeah. Exactly. Yeah. A very, I think we can say a sketchy individual. He was involved in scandals with SNC-Lavalin of embezzling money when SNC was building a new super hospital in Montreal. He had ties with arms dealers and had a lot of, his training was as a doctor, but had a lot of other fingers in other pies. And he was the chair of CSIRC for a period of time. And eventually he went back, he had dual citizenship with Bermuda, and went back home, and he passed away. He had cancer and he passed away, but it speaks to the questionableness of his nature that there were reports that he passed away, but the RCMP wouldn't believe it until they sent identification of the body back and wouldn't believe the news reports because they wouldn't put it past him to fake his death or find a way to escape. And so he was the chair of CSIRC for a little while. There's also people who are on CSIRC who, the CSIRC member who reviewed the protest papers case had served on the boards of oil companies and continued to have shares in oil companies and pipeline companies while he was reviewing that case. So even though they're independent and civilian, it doesn't necessarily mean that it's trustworthy or that we're going to get the best results. With the NSIRA, I have to say there's been a few appointments that have really been made us a bit more hopeful. So the new chair of that body is Murray Rankin, who's an outgoing NDP MP and has been very good on not everything, but on most domestic national security issues. There's some things on international relations we would disagree about, but on domestic issues, he's been very good. And Craig Forsees, who's one of the leading legal experts on civil liberties and national security, has also been appointed to the body. Again, we don't always agree, but these are two people who in the past 30 years we would have never seen on CSIRC. So the fact that they're on this new body is hopeful and does give hope that they will be more stringent. There's a new Committee of Parliamentarians that we were skeptical about. That's an all-party, well, not all-party, but who doesn't, I guess it includes all members from all official parties that have official status in Parliament. So it doesn't include the Bloc, the Greens, or now the People's Party, but has NDP, Conservatives, and Liberals. And their reports have been much stronger than we expected. There are significant limits on what they're able to access based on the laws that brought the committee into place, but it's actually been much better than we expected. So So there is hope, but at the same time, they're also restricted. And because they're restricted on judging whether or not these bodies are following the laws that are put in place. And so as long as the laws that are put in place are problematic and are giving these kinds of powers, so sometimes the issue isn't just that they're violating the use of these powers, it's what the powers allow them to do in the first place. So there's a good chance with the disruption powers. I mentioned it came in in 2015 with Bill C-51 under the Conservatives. They never used those warranted, the ones that they would need a warrant for, powers, since it came into place. And the reason why they didn't use those powers is because they knew that the law violated the Charter and that there would be a constitutional challenge if they used it. So we thought that the Liberals would roll those back and get rid of those powers in Bill C-59. What instead they did is they made it what they call charter compliant, bringing in the list of what you can do under a warrant to try to make it more legal. So not disputing the fact that a secret intelligence agency should have these powers, but just finding a way so that it can stand up to a constitutional challenge if that ever comes, which to us is highly concerning. And that's the kind of thing that a review agency, if they have a lot of guts, they'll speak out about. But in the past, we haven't seen that, and if they're following what their mandate is, they're supposed to be reviewing the work that the agency is doing, and they can raise flags, but it's questionable about whether or not they'll raise flags in order to change the policies that are on the books. If they see rampant problems, hopefully, I have faith that they will, because of the new people who have been appointed, but it's still a major concern that we have.
Behind you, Kathy.
So what can we do in this current climate as activists to protect ourselves?
Right. That's a good question. I think one of the things is to so one of the things is engaging, and I mentioned it's engaging with our representatives and making sure that they know that people are concerned about it, especially during the elections right now. But we've been engaging with MPs for a long time, and we haven't seen, a lot of changes, and it's difficult. So often, what we need to do is make sure that we're supporting the people who are being targeted and the people who are facing the brunt of this. So sometimes it might be helping to support the legal fund campaigns for individuals who are targeted by these laws. It's by working together to call out, as I mentioned, often a lot of this is based on racist rhetoric, on unproven rhetoric, and so being willing to call that out when we hear it and speaking up about it and standing with the people who are being targeted by it. And I think there's ways that we can just protect the work that we're doing. One of the things I didn't get into here but just came out in the last few days is that there is a major push by this group the Canadian government is part of called the Five Eyes. It's the UK, US, New Zealand, Australia, and Canada. And they do a lot of information sharing and share all their surveillance with each other. They have a major push right now to get rid of encryption of consumer applications. I'm not explaining that very well, but the examples are, the main example is WhatsApp. Who here uses WhatsApp? Okay. Who here uses Signal? Maybe a few people. Who here uses Facebook Messenger? Okay. So WhatsApp and Signal are encrypted. Facebook Messenger, you can actually encrypt it if you turn on that tool, but it's not by default. And it's often used by activists, human rights defenders around the world to make sure that their communications are safe. And even just for regular people who are worried about what Facebook could be looking at or what the companies could be looking at, because we've seen them using our information in ways that aren't legal and aren't ethical. Those 5 countries right now are doing a major push. There was a joint letter from the US, the UK, and Australia just this week calling on Facebook to ban encryption on all of their platforms and to create what they call a backdoor so that they'll be able to, their idea is that, well, you could also maybe keep it encrypted, but make a way so that we can watch the conversation before it gets encrypted. And they try to pretend that it will only be them who can use it. But if Facebook doesn't allow, and we use Facebook so much, it's a whole other conversation, but those tools are essential for so many people for their conversations and to make sure that their rights are protected. And also in protecting commercial activities to protect our privacy. Basically what we've seen is that in other instances where the NSA, for example, has created tools that can undermine encryption, that eventually some of them get leaked, they get hacked themselves, and then they're used by other countries, by other entities, by criminal entities, in order to access our private information. So one of the things is to use those tools, but also keep an eye out and make sure that when this coming debate happens, that we're often told, and the reason it's often given is that it's also used, and it is legitimate, but it can't, it isn't only about that, but that it's used by it is used by criminal activity, by criminal organizations, terrorist organizations. Often it's framed as child pornographers who are using it the most, and that has become a problem. But it's a long conversation. But what at the heart of it is that for the last decade, the social media companies haven't taken that seriously and have essentially not really addressed those problems in other ways that they can. And so the easiest way for them to address it now is to say, well, no encryption for anybody. We're just going to undermine it, and we're just going to get rid of it. And so that's a big concern that's happening right now. But I'd say still using those tools right now is important, but I think making sure that those tools and making sure that it's clear that this is a freedom of expression, but also a freedom of association and assembly, and also just a right to privacy. We're told that we should be willing to give up our privacy if we have nothing to hide. But there's so many things that we don't need shared and that can be used in so many ways that we don't even know about, that even if you're not trying to hide something, there's a reason why not to share it. And if you're not doing it for yourself, another great argument is that you're doing it for other people around you. They may have, they have a right to that privacy too. And if we're willing to give it up, it means that we're giving it up for everyone. So that's another thing that I think we can be doing to help. Yeah, thanks.
Tim, we have time for one more question.
That'd be great.
Okay, anybody have? You get your choice. You get your choice.
My choice? You've had your hand up for a while. It's very short. Does my MP have any elevated status in this sticky mess, or they're just like us?
Just any MP? No. Unless they're on the Committee of Parliamentarians that's reviewing national security, they actually have very little access. And to be honest, what we found is that MPs are taken up by so many files that even when we go in front of the committees that are studying this, it's very difficult for them to have their own, have done their own research and have their own very strong opinions, and that isn't based on what they're getting through Public Safety Canada or through the security agencies because, so they don't have any extra power. It's not a reason not to approach them and talk about it. They don't necessarily have access to more information. But one of the groups we've worked with was the No-Fly List Kids. They are a group whose children were being flagged by the No-Fly List because their names were similar to people on the No-Fly List. And there was no way in Canada to discern them before they got to the airport and at the ticket counter, they're like, well, this person is 6 years old, but they're still flagged, so I have to make you wait, I have to check. So it was through their campaign for 5 years, working to get MPs to write letters. They eventually got 2/3 of MPs to write letters to Public Safety Canada and to Minister Goodale to bring in a redress system, and it was finally started, and the first parts of it were put in with Bill C-59, which is a good start. There's other problems with no-fly lists. So eventually we can build that power through MPs, but at the same time, it's not every case that is as clear-cut as making sure that, a 6-year-old isn't being flagged as somebody on a terrorist watch list. So, yeah.
Thank you, Tim.
Yeah, I can, if you want to.
Well, my question is related to that, the Secure Air Traffic Act.
Yes.
Is something that they developed now. So they want to give people identifiable numbers. So is this good for human rights, or is it?
It's a good step. It will help people who are falsely flagged. So for example, if you have the same name as somebody who's on the no-fly list, but it doesn't do anything for people who are actually on the no-fly list and don't know that they're actually the person on the no-fly list because they're not informed of it, and who don't have access to the information that's being used against them to keep them on the no-fly list. So our position is actually that we've never seen evidence that the no-fly list has prevented a terrorist act in Canada. and that there's criminal laws in place that they can use to keep people and that would have to go through court, and that would be a clear warrant issued by a judge that would keep somebody from traveling if they're going to commit a crime, and that we should instead abolish the no-fly list and use those powers if we want to keep people from flying to commit a terrorist activity or committing a crime on a plane, because the program is so flawed and never been shown to be effective. Yeah. Thanks, everyone. I think that's it. I actually have to run through. Thanks so much.
So before everyone leaves, I'd like to present Tim with a gift
Thank you.
from all of us. Thank you so
very
much.
much. Thanks.
I kind of thought maybe an hour 15 wasn't going to be long
my
enough.
God,
Are you able to hang around the group if they have
I'm
some
going to have to
questions?
get going. Actually,
You're
I
gonna
have
have
a
to
flight
get
to
going.
catch. So
Thank you so much.
Thanks. Thank
This
you.
was very, it was a very, what's the word I'm using? We've donated for quite a while.
Yeah.
We probably don't know exactly what you're doing all the time, but we now know that it's very important, your role in keeping us protected. Because we don't know what the government's doing behind our back, but now we do. Thank you so much, and continued success. Thank you.
Thanks a lot. Thanks.
Let's